Hello, everyone. This is Brian Jackson. Welcome to Lawed Up. This episode, we're going to focus on criminal law. The whole purpose about these episodes is to help people better understand the law, not just if you're an attorney or law school, but everyone. So this is one where we're focusing a little bit about what's taught in law school, and so everyone has to take a criminal law class their first year, and usually a lot of stuff that you see in that class is in the bar exam, usually in a multiple choice fashion. And so what this class is it's just teaching you how to understand the criminal law statute. So we have 50 states, and all states aren't creating the same criminal law statutes. Everyone has a different legislature, so technically it's up to every state to decide how they're going to come up with their criminal laws and how they're going to be interpreted. But still, there's organizations and individuals that put some model, so it's called the Model Penal Code, penal, criminal penalty code. So that's what it's called, the Model Penal Code. So there's these model codes that a lot of states can look to see if they want to incorporate some of the stuff that's in the Model Penal Code, or if they want to come up with their own stuff. And so there's a lot of crimes that can generally be the same and across the board, and it's tricky because in law school there's 50 states with 50 different laws, but law schools and the bar exams are trying to make teaching as uniform as possible. But yeah, there's a lot of stuff that generally applies across the board with all 50 states that can be taught to everyone. So the big thing that they teach in criminal law, the big focus and main point, is just how to interpret the criminal law statute and how this criminal law statute works. And so you kind of, there's in every statute at the beginning, it has definitions and then also kind of some disclaimers on if there's something missing, then this is what it means. So that's the big thing is knowing if there's a specific word missing, what do you do and how is that interpreted? And that's important once we start getting into this and talking about mental elements. And that's really the big thing. The very first part of criminal law is mental element. And I remember when I was in criminal law, our teacher was cold calling everyone, trying to ask us what the mental elements are, and no one could quite understand what he was getting at. So my big claim to fame is I finally, in my textbook, raised my hand and read specifically the requirements. And so the word is mens rea. And so it's a Latin term. And again, that's having a mental element and how that mental element applies to all the crimes in the Model Penal Code. And so there's a lot of crimes where you have to have a mental intent to commit the crime. So I have to so if we're talking about murder, I have to have the intent to kill. I have to, or if we're talking about assault, the intent to commit bodily harm, serious bodily injury. There's different levels of assault on individuals, or with robbery or theft, the intent to permanently deprive. And so what it's saying is if intent isn't in there, like if there's a crime and it doesn't say that I intentionally have to have the intent to commit murder, statutes typically say that intent is red end. And so it's a higher burden of proof you have to prove. You have to prove that it wasn't something lower than intent. And so something lower than intent could be negligence. Maybe you didn't have the mental element to kill somebody, but maybe you were negligent. And so if you were negligent and didn't have the intent to kill, then the prosecutor can't prove murder, because murder is the intent to kill. And so the lower one would be, it's usually called negligent homicide. So you were negligent in what you did, meaning that you didn't have a mental attitude to, again, kill somebody, but you just did something that was dumb that caused someone to pass away. So, for example, like if I'm cleaning my gun or something, and there's a bullet in the gun still, and it goes off, and somehow it unfortunately kills somebody, you could argue that that was negligent homicide and not murder, because I wasn't intending to kill someone. And so if it's a lower standard negligence, usually the statute specifically has to say that to lower the intent element that has to be proven. But also in a lot of traffic, more civil stuff that doesn't have, they just have fines attached to them and no jail time attached. Usually those ones don't have a mental element either. So I was speeding, maybe I didn't know I was speeding, but if I was speeding, I can still be charged. Or if I didn't stop at a stop sign and I thought I stopped for whatever reason. Or so yeah, there's some stuff where you just didn't do it, and there's no mental element necessarily involved. So really, that's the first part of the criminal law part in law school, is teaching law students that mens rea, that intent to kill. And then you focus a lot on the bigger crimes, murder, and then they start talking about lower elements and or defenses and exceptions. And then they talk about specific elements for some of the bigger crimes that kind of apply across the board for all the states. So yeah, most states have a intent to kill for murder. And then obviously you have to actually have the victim had to have actually passed away, and your actions had to have caused the murder. So I think there's some cases out there where maybe somebody got hurt by somebody and it aggravated a pre-existing condition. And maybe the medical examiner determined that it was based off the pre-existing condition and maybe not necessarily based off the blunt trauma that they died from. So that can technically be an offense as, hey, well, I didn't actually cause the death of this person. It was somebody else, but there's still stuff to claim that, well, you were the aggravating factor. So that's kind of the fight in some scenarios on, did I actually do this or not, or if it was something else. And then also what they look at too with some of these claims is, with elements, is like, for example, there's burglary and robbery. And so a lot of people don't know the difference between burglary and robbery. Robbery is usually going up to somebody and using force to take stuff from them. So it's kind of a higher level of theft. So I go up to somebody, have a knife, I say, give me your money. That's robbery. And usually aggravated robbery, because if you got a knife that can cause death. I have a weapon that can cause death. If I'm just using my fist or something, it may not be aggravated, but I'm still using force to take that from them. So you kind of have the lower level of theft, where you just go in the store and you take money or or you or you take items from the store, so that's theft. And then robbery, if I go to the store and I use a knife or gun to take stuff from the store. And then you have burglary. And so burglary is usually the entering and breaking into every state's different, but it's typically your home. It can be a business sometimes, but a lot of states are focused on entering and breaking into a home. Sometimes there's a requirement where it has to be at night, sometimes not. And you have to actually break and enter into. So, I mean, there's some cases where the door was open and they just walked in. So is that considered breaking and entering? And so you have to actually, do something, And so, I mean, yeah, that's a big issue is if the door's open, is that breaking and entering? If the door is locked or if the door is closed, then that's more, you're probably entered, and maybe you didn't break the door, but maybe claim that you entered or broke a window or the door, then obviously that's more breaking and entering. And then you have to have the intent to commit a crime in the home. So it doesn't matter what kind of crime it is, even if it's a small crime, and a weird crime, like you forge somebody's name on a voting ballot. So you break and enter and forge someone's name, so that could be considered burglary. But if you don't have, if you just break and enter and you don't have the intent to commit a crime at the time you broke and entered, for whatever reason, you just wanted to go inside this home, maybe you're freezing cold, who knows, some weird circumstance, and then after the fact, you commit a crime, it may not be burglary. Like if, you're freezing cold, you go into a house, and then the homeowner comes after you and you guys get in a scruffle and some kind of crime is committed, that may not be burglary. It may just be trespassing and or assault if you assault the individual. So there's some nuances there. That's a big thing that you focus on in criminal law is those elements. Then also in murder, they talk about some of the defenses or lower kind of murder types of claims. So there's ones where it like cold blood murder, like you plan for months to take this person out, and you had the intent to kill for some purpose or whatever. There's other ones where that may be a lower type of murder where you weren't doing it in cold blood and you were doing it in warm, hot blood because somebody made you mad, and somebody ticked you off emotionally, and you're not in your right emotional state, and you do something that you may not have done had you been in your proper state because someone aggravated you. So whether someone called you a name, and or you found that, the big one is you found your spouse in bed with someone else, maybe hard, and you terminate one or the other. It may be hard to have a murder scenario in that situation. It may be a lower depraved heart charge if states have stuff like that, or it could be also could be used as a defense. Like if the state charges you with murder in that scenario, you could say that, well, I didn't have the intent to kill per se until I got there, and then I had the depraved heart, and things got out of hand there. So those are the big things they look at, and those are the things they kind of ask for in on the bar exam. They ask about those elements: burglary, depraved heart, robbery, and murder. And then the other thing is also whether or not you were part of a crime. Maybe you didn't per se do the crime, but you can still be charged for a crime for being an accomplice to a crime. So if you were the person that was the getaway car after somebody robbed a store and you drove off, you could still technically be charged with the same crime for being an accomplice and or conspirator. So maybe you guys had, maybe I had a boss, the driver and the person running the store had a boss that said, hey, we need you to go do this and get this money for us. And so if that boss was kind of the mastermind, or you had other people that were part of the planning process, they can also be charged as conspirators to the crime as well. And then also another thing that they talk about in the criminal law realm in this class is felony murder. So that's a big one, and can be tricky and sometimes not fair in some scenarios. But I guess the purpose of the statute is that if you're committing a crime, that that you're on the hook for whatever happens for that crime. So it's called a felony murder crime. So if you're committing a felony and something happens to somebody during the attempt to commit the crime, like if you go into somebody's house and you're committing burglary and some kind of scuffle happens and somebody dies and maybe you weren't part of it, maybe it was a friend, or maybe it was the aggressor, or maybe the homeowner, and maybe the homeowner kills one of your guys, but you weren't involved at all in the killing, or maybe one of your friends killed the homeowner. You can still be charged for murder, felony murder, because you were committing a felony, and during that time somebody passed away as a result. Or, for example, if you're in a getaway car too and you get in a car accident with somebody and that person dies, then you can also be charged for felony murder for being a part of that. And also, or if somebody gets hurt, there may be states that have some kind of felony assault as well, being part of that. And so those ones can sometimes be controversial because, not all felonies are created equally. So, going back to the forging of a ballot, that is somewhat serious felony, but it's a little bit different than committing a crime towards a person or trying to deprive person of property. But if for whatever reason while you're forging the ballot, somehow somebody dies while you're forging the ballot, you can be charged for felony murder. And so there's a lot of scenarios like that with younger 20-year-olds where they may have been doing something just really stupid and it wasn't more of a serious felony, but still stupid. But then somehow there's just an unlikely event where somebody died. And so instead of being on the hook for like a third-degree felony where maybe if you have a clean record and you haven't done anything too serious, it might just be something the prosecutor might be able to resolve with you without having to serve any jail time, maybe some kind of probation and or agreement, committing new crimes that they'll dismiss it after a certain amount of time. But then if somebody dies, then you could be on a hook for more serious crime, felony murder. So that's kind of really how the class works in a nutshell with criminal law. And so I guess to add onto that, in what happens when you step into the courthouse and the procedure and how things kind of work on that, I'll focus on that too in this. And so basically how things start out when a crime is committed. Typically, you have somebody go and investigate the crime and take evidence and take witness statements. And so that usually falls in the hands of police officers. They are the investigators. They're just investigating the crime. That can include detectives. It can include, if it's a federal crime, then the FBI gets involved. Because they're like the federal police officers. So they're just investigating and gathering evidence. And if they think there's enough evidence to that a crime has been committed, then in some scenarios they can arrest that individual. If they have probable cause that that person has committed a crime, then they can arrest them and take them away. There's a lot to unpack there, though, as it relates to the Fourth Amendment and probable cause and whether or not the crime was committed in their presence and stuff like that, and getting arrest warrants. But generally, if someone's committed a crime, they can arrest them or get an arrest warrant. And so typically, like in a domestic violence situation, there's domestic violence. Police officer determines that the male was the aggressor, and he goes to, and then he arrests him and puts him in jail. And usually, technically at that point, a charge hasn't been made, and so who actually makes the charge for more of the serious crimes, if it's a traffic violation, sometimes cities have it where prosecutors don't even make the charge, but in all other circumstances, it's the prosecutors that make charges, like misdemeanors and felonies. They have to go through a screening process and look at the police reports and evidence and say, okay, yeah, we think there's probable cause to charge this person with a crime. So when you go to jail and you're booked in jail, you're not technically charged with a crime at that time. And usually if you stay overnight and if you're in there for a while and you don't get bailed out, then you have it's usually 24, 48 hours to be put before a judge, and for a judge to determine if there's probable cause to continue to detain you in jail. And typically typically the go-to is that everyone should be released from jail. And jail time isn't supposed to be imposed until you have been found guilty of a crime. And so there's kind of what you look at in the bail process is determine is if there's a reason why this person needs to be detained while charges are pending, while this case is going on and you get up to a jury trial. And so there's certain factors, but again, the presumption is that the person should be released, that they should not be detained. And so the only reason to detain them is factors such as danger to the community. So if somebody is a danger to the community, a judge could require detainment. But also, before you get to detainment, you determine if bail is sufficient. So meaning that somebody puts up some kind of collateral as, I'm putting up this money, and all of this is just to make sure that this person comes to court and or isn't a danger to community. And so first they look at like if somebody has enough collateral that can assure that they will be able to show up to court. And that's only, again, the analysis on if if they'll show up in court. Because if there's concerns that this person might be a flight risk, so that's the other thing: is this person a flight risk? Will they actually show up to court? So some factors they look at is, does this person have outstanding warrants? Has this person missed court dates in the past on other charges? And if so, then there's more of a burden and more of a basis to say, hey, we might need a bail amount to assure that this person will come back. And then if that's not the case, if then also, if they look at too, if you actually live in the community, like if you're just a passerby or something, then bail might be required too, to ensure that you show up to court. And then we go back to, again, whether or not you're a danger to the community. And so that's more really what the judges look hard at, on whether or not this person should be in jail or not while the charges are pending. Are they a danger to community? And so obviously if someone has committed murder, that's a good argument, or some more serious high felony cases, first degree felony. And so usually highest degree is first degree, which are the more serious crimes where life and big prison time can be imposed. And then it goes down to second degree felony, which is a little bit less, maybe 10 years in prison-ish, could be 20 years. And then third degree is more around 5 to 3 years in prison, and those are maximum. So if they're the more serious crimes, then the judge might say, you know what, you're too dangerous to the community. There's a chance you might commit more crime. And so we're not going to allow any bail. There's no money, even if it's $1 million, $10 million, $5 million, there's no money that we're going to allow you to put up. We're just not going to let you get out because of this, because of how dangerous you are. So that's kind of the bail process. And there's some states, even before all this, where depending on the crime, you actually need a grand jury to even, instead of the prosecutor doing the screening and determining whether or not a crime has been committed, and making that charge, there's some states where they will actually call a grand jury and present evidence to the grand jury, and then the grand jury will decide whether or not to make a charge of murder or other charges. And it's definitely a more loose kind of trial. And sometimes the defense attorney can't even show up, or even the victim, to testify on their behalf. And there's definitely a lot less rights and rules involved compared to like a typical jury trial. And so once you're charged, with other states though, there's some judges that determine the probable cause down the road. So like some states, prosecutor makes the charge, but then at some point there still needs to be a probable cause hearing, and so there's a preliminary hearing set. So you can have a preliminary hearing where a judge needs to determine whether or not there's even enough evidence to make a charge. So probable cause is more than likely that a crime was committed. And so if there's not more than likely evidence, then that charges are dropped at that point. So it's kind of a screening process too, to make sure that the state has to jump through to make sure they're not going rogue, and that there's fairness and transparency involved. And the other thing I would note too is, I did a little bit of criminal law in my early years, because I interned when I was in law school with the public defender's office, and so that's all I knew how to do. So that's kind of what I started doing starting out. And a lot of people would come to me and be like, well, how can you represent those criminals and all the crimes they committed? I don't look at that at all as an attorney. And, even if somebody has done a serious crime and, it was on video and everyone knew that it happened, we still all have rights. And there's still a process and procedure in evidence and the use of evidence and proving those elements of a crime and determining kind of sentencing should be done and negotiating and so everyone, no matter what the crime they had committed, has a right to go through that process and an attorney too to make sure that process is properly followed. As I guess what's important as a criminal defense attorney is they are kind of the watchdogs of the government in the criminal arena and making sure that the government isn't going rogue. Because I've seen it where I've seen areas where some states are a lot more loose on the right to an attorney and have a little bit higher standards than some other states as far as getting a public defender. And so there's a lot of people who go through the criminal system without an attorney. And I have noticed, I've been in different states and seen one state where it's a lot lower barrier and it's really hard to waive your right to an attorney. A judge will scrutinize you really hard and it's like pulling teeth. Are you really sure you want to do this on your own? And then in another state where it's like, it's just day in a life. Oh yeah, you want to waive your right to attorney, no problem. And that's kind of the go-to. And I've seen the issue with the other state that is more lax on the right to attorney is because you have these lay people representing themselves and they don't understand the criminal justice system. They don't understand how to analyze a case, what the elements of the crime are, what defenses can be, some issues that the state might have in proving their case, and as far as the evidence that they can get in, and some evidence that may be suppressed because it wasn't evidence that was properly seized by the government under a warrant or other basis. And so they're just in the dark. And so these prosecutors are used to giving really bad deals to these people. And even if the cases are bad and there's really no one with the know-how to push back on these prosecutors. And so you have these prosecutors that are giving really bad sanctions to people for crimes, where if you had a system where there was more right to counsel public defenders, or if everyone had an attorney, these people would probably be getting better deals and they wouldn't be more serious and they would be more fair based off the evidence and the facts. And so it does very important to have criminal defense attorneys to push on the state a little, to question the evidence, what they have and their burden of proof and the type of charge they made. And to put pressure on them and if the state has done everything properly, great. But it's just good to have somebody there to screen that and to make sure that they have done everything proper, that the charges are proper, that they have the evidence they need to prove their case, and there's nothing weird going on going with the case. And so, if there is someone that did a horrible thing and the state can prove it, then great. But it's good to make sure that there's someone screening that to make sure the state does everything right. So sometimes just having a criminal defense attorney, it's just holding their hand, and maybe ultimately they'll get a serious sanction and some serious prison time. But it's better than going it on your own, especially if you have to go to trial. Like, trials are so foreign; they are a different world as far as evidence, how it works, what's coming in, testimony, questions, objections, knowing what evidence can and can't come in. Like, if you're facing a felony charge with prison time and you want to go to trial, you gotta get an attorney. If you're facing loss of your liberty up to 3+ years, you've got to get an attorney, because if you have no background in the law, then you're going to get eaten alive, because there are so many classes that you have to take in law school to even know how to do a trial. And even when you get out of law school, you really don't know how to do a trial. And it takes a long time to understand and to be prepared and be competent and have that and have that knowledge that you can actually do a trial. Like, there's one class, Rules of Evidence, where it's specifically focused on telling you how evidence can come in at a trial, whether or not be a civil or criminal trial. So that's a whole semester that you have to take, and it's drinking from a water hose too. And then also criminal procedure too. You've got to understand criminal procedure and suppression of evidence, and the Fourth Amendment and the Fifth Amendment and the Sixth Amendment, because there could be some good defenses there. There could be some evidence that can be suppressed, and it has to be suppressed before you even go to trial. And so if you haven't suppressed the evidence, and it could have been suppressed, then that's a big whammy on you for not knowing that. And that's another entire class that some people don't even take in law school. Sometimes it's an elective, criminal procedure. This is a separate class from the class I've been explaining in the podcast. And this class focuses more on the Fourth Amendment rights, right to an attorney, and right to remain silent, stuff like that, and then what the remedies are if those rights are violated, which is typically a suppression of evidence. It's not necessarily the case gets dismissed. It's just, if I admitted that I murdered somebody or admitted to a crime or anything in the presence of a police officer, and they didn't read me my rights, or my attorney wasn't there and I asked for an attorney, that admission may not be able to come in at trial. And so that's a big thing. It's if really that is the case for the state, and it's that admission, and there could be issues if you were just coerced, and or there were bad tactics in trying to get that admission out of you, and it really wasn't a proper admission, then yeah, you don't want that admission to come into trial, especially if that's what the case the state is hanging their hat on to prove it against you. So that's kind of the process generally, and so when that charge is made after the grand jury or after prosecutor makes the charge, then you get all these pre-trial conferences, and you have a pre-trial conference, and that's kind of prepping for pre-trial. And between a trial and the charge being made, what is supposed to happen is the state is supposed to give you the evidence that they have on proving their case. And so that's also important to have an attorney to understand and look at that evidence, to make sure all the evidence is there, and make sure that you're getting all the evidence, and the prosecutor's office isn't withholding any evidence or any tampering with evidence or anything, and that you have an attorney that can kind of do investigation for you. And yeah, what stinks is defendants are kind of at a disadvantage, because prosecutors there's tons of money invested in their investigation of the case. They've got police officers, forensics, all these labs back behind them, expert witnesses they can call. And then on the defense attorney's side, it's kind of your dime to pay for an attorney to investigate for you, and to have an attorney perhaps pay and off your dollar again to pay for expert witnesses and do forensic analysis or any other analysis that need to be made on your behalf. And so defense individuals in a defense standpoint are already at a disadvantage, as it just comes from a monetary standpoint. And so again, that's why it's important to have a criminal defense attorney on your side that can ensure that all the evidence is there. And because there are a lot of times, again, like I say, like with people just representing themselves, prosecutors may not think of all the evidence that there is, and may not give everyone that is self-represented the evidence that exists. And a lot of times I have to push really hard on prosecutors and say, hey, we're missing this. Police report says that there's this evidence. Where is this? And so, again, that's another reason why it's important to have a criminal defense attorney. And so what happens usually at those pretrial conferences is typically it's just negotiating with the prosecutor, and it's really hard too, because a lot of these prosecutors have a really high caseload, and I guess I'll just say, maybe some people might take offense to this. It's really easy to be a prosecutor, because you make the charge and you watch the paint dry, essentially. And criminal defense attorney really has to do a lot of legwork, looking at all the evidence, looking at all the defenses. And so when you approach the prosecutor, it's really hard because of their high caseload to negotiate, because there's tons of other people in the courtroom. It's not just you have your own pretrial conference. There's tons of people on the docket. It's probably a morning docket, and there's going to be 30 or 40 people there that have been charged with a crime as well, some represented, some not represented. And the prosecutor has to somehow talk to everyone and give them offers and negotiate deals. And so you only get like maybe 5-10 minutes to talk to the prosecutor. And if the prosecutor doesn't have their head wrapped around the case, you have to teach them and show them very quickly, these are the facts, these are the issues I see, and get them up to speed, because I bet you they're not going to be as up to speed as you are on the case. And then based off what the attorney sees, try and negotiate a better deal for their client based off the evidence. And so usually that's how it works, is you're just negotiating with the prosecutor. Sometimes attorneys can call prosecutors on the phone, but usually prosecutors have policies where they'll only talk to you in the courtroom, but some are nice, some aren't. So it's kind of an uphill battle trying to negotiate deals as well. So you have to be really on your toes, know your stuff, know how to be diplomatic, know what you're looking for, and know how to convince a prosecutor that, hey, this might not be a case you want to take trial, and let's try and figure something else out here. So that's it. Criminal defense, generally how it works. First half, kind of how it works with in law school, and then also in the real world. It is a foreign thing completely. Not a lot of people have had to be in the criminal defense world, but it's good to understand and know about. And again, that's where a lot of those constitutional rights kick in, and it's very important process, and criminal defense attorneys are a crucial element going through that process. This is Brian Jackson. Thanks for listening to another episode. Lot Up.